Hello, I am Dr. John Cathanon, and I am the instructor for this course, AJS109, Substantive Criminal Law, which is an online course. A crime is a wrong defined in law that elicits punishment. Now, there are two critical aspects of this definition. First, it has to be a wrong defined in law. That means there has to have been a statute that was passed by the legislature and signed into law by the chief executive, at the state level, the governor, at the national level, the president. Although governors and presidents can veto laws, and then they only become a written statute if the legislature, Congress in the national level, the state legislatures in the local level, if they override the veto by 2/3 vote. But in any event, this has to be a law that was passed and is written in statute. The second thing is it has to have punishment. A law which forbids something which has no punishment isn't really a crime. It's just you did something which they didn't want you to do, but there's no penalty. So it has to be in statute, and it has to have a punishment. If that's the case, it's a crime. Now, let's talk about the concepts of crime. This gets a little philosophical. Natural crimes are crimes that are deeply wrong and recognized as such by most people. These are acts that are wrong in themselves, and the Latin legal term for a crime that is wrong in itself is malum in se. That means bad or evil in itself. Now, these are crimes like theft, rape, murder. These are crimes that everybody intuitively knows without having to take a law course or read it somewhere. We intuitively know that these are horrible, terrible acts. Malum in se. However, there are other crimes. There are other violations of law that may be just violations, which are non-crimes, that are not evil in themselves. Other crimes created by law are crimes only because a statute makes it so. And these are often not intuitively evil. Jaywalking, operating an unlicensed business. You don't instinctively know that it's bad to cross the street in the middle. You don't instinctively know that you need to get a business license for a certain business or have an occupational license to do a certain type of work. These are only illegal because we say they're illegal. And we call them malum prohibitum, bad because we prohibit them. Now, the reason why we have these types of laws is that in a complex society, where a lot of people have to live and interact with each other, where we have very advanced forms of industry and commerce. I mean, we're not just a bunch of farmers like in the Middle Ages and shopkeepers. We have to pass laws to control the behavior of people because certain acts, although not intrinsically bad, if they're committed by people, will cause disruption and chaos in society. You can't have people going through red lights. You can't have people jaywalking because you would have accidents and traffic wouldn't go right. It wouldn't be safe to live near or cross a street. So these are not intuitively wrong, but we need to make them illegal. Thus, they are malum prohibitum. And again, they generally have lesser penalties than the other laws which are evil in themselves. But basically, that's what is a crime, and those are the general categories of crimes philosophically. And that takes care of this slide. Now let's talk about the difference between criminal law and civil law. You hear those terms thrown about a lot. A criminal action involves the breaking of a criminal law, a recognition that the offense is against all members of society and not just the victim. And this is an important concept. Even though most criminal laws are committed against an individual, somebody is beaten, somebody is murdered, somebody is raped, somebody's property is stolen. Even though they're offenses against individual people, legally, it is an offense against all of society. There'll be a public proceeding if it's a criminal action. We are not a totalitarian nation that has secret trials. Now, there are some exceptions to this. Juvenile proceedings are often closed to the public. But that's not for nefarious purposes. That's to protect the privacy of the child. Certain terrorism trials are also not public, but that's very unusual situations. Because these criminal acts are acts against everybody and not just the victim, they are prosecuted by the state. The state pays the prosecutor, who's a state employee, and the title of the action is the people of the state of Arizona versus John Doe, or whoever the defendant is. In addition, if it's a criminal case, the accused is going to be afforded special rights and protections. The right to a jury trial, the right not to be subjected to cruel and unusual punishment, all of the protections in the Bill of Rights against illegal searches, illegal seizures, all of these rights the defendant has, and they're enforced in court. In addition, if it's a criminal case, there is possible incarceration and fines paid to the government as a form of punishment. The more serious crimes are felonies. You can go to prison for a felony. The less serious ones are misdemeanors. They usually involve just a fine or a very short jail term. There are also acts against criminal law that are not technically crimes. These are violations where you don't get a criminal record, and they're usually just fines, jaywalking, speeding, littering, those types of things. In addition, if it's a criminal case, there is blame and condemnation to the guilty party. When you are convicted or plead guilty of a criminal act, you are labeled a criminal. And there are a number of negative effects: condemnation by society, a record, and if it's a really serious criminal act, you may be prohibited in the future from certain jobs or certain occupational licenses, voting, and other things like that. So that's a criminal action, serious stuff. There are also civil actions. A civil action involves a private harm by one person against another. And so that when two people disagree about who owns something, or whether somebody has to repair damage that was caused by one person to another, or who has custody of a child, there's all sorts of civil issues. When two people disagree, rather than have them duke it out on the streets, we created a civil court system where they can go, usually represented by lawyers, except in small claims court, and they can argue their side of the case before a neutral magistrate. And we call that neutral magistrate a judge. In addition, if it's a civil action, there is compensation to the victim for harm done. There is no criminal punishment. There's no jail or imprisonment. In a civil action, two people disagree, and a judge decides who is right, and the judge will give them damages. Compensatory damages to compensate them from the harm done. Sometimes there's punitive damages to deter that kind of behavior in the future. Courts can also issue orders making one party do something or refrain from doing something, like orders of protection. So those are civil actions, private disputes between people that we resolve in court with a judge and rules rather than in the street. But keep in mind that the same act can generate both a criminal prosecution and a civil lawsuit. If I'm drunk and I drive my car into you and I damage your car, I'm going to be prosecuted for drunk driving. And if my insurance won't pay you or I don't have insurance, you can go to court and you can civilly sue me to get the money to repair your car because I damaged your car against the law. So that's the difference between criminal and civil law. Okay, now let's talk about the elements of a crime, the things that you have to do or have to be present in order for a crime to occur. And the first and most obvious thing that has to occur is you have to do an act. And this act that you do, we call it conduct. And it has to be a voluntary act. It can't be a reflexive act. It can't be something that you do under hypnosis, or it can't be something that you performed in a semi-conscious state. So as an example, if a person were walking down the street and they suddenly went into an epileptic seizure and their arms and legs were thrashing around quite violently, and somebody came over to help them and knelt down beside them, trying to put a coat under their head so they didn't bang their head against the ground. And as the person were doing that, the individual having the convulsion, their arm flung upwards and struck the person in the nose and broke the person helping's nose, that would not be a voluntary act. That would not be an assault charge for injuring somebody because it was reflexive. Likewise, if you're hypnotized, although that's kind of questionable if people can be hypnotized, that wouldn't be a criminal act if you did something illegal, or if you were semi-conscious. Although if you brought the semi-consciousness onto yourself by drinking too much or taking drugs, there could be some liability, and we'll discuss that later. What else aren't conduct? Well, words generally are not conduct. Now, there are exceptions to this. If I threaten to kill you and I cause you alarm, that could be an illegal act. If I said that if you didn't do something or give me money, I would expose a secret or harm somebody, that would be an illegal act. But words themselves generally are not crimes. So if two people are sitting in a bar and they're talking about robbing a bank and a cop overhears them, just talking that way is not an illegal act. Talk is cheap. We need more than just that. What else? Omissions generally are not criminal acts. If you're walking down the street and you see somebody in a lake drowning, and you can swim and easily rescue them, or there's a life preserver right by the shore you could toss to them, and you don't toss it to them, that's an omission. You fail to act. Generally, you are not guilty of any criminal act for not helping that person and actually watching them die. Because in our society, we are extremely hesitant to require people to do things with a criminal penalty if they don't. Now, there are exceptions. We have a law that says you have to file your income tax. That's an omission where you can have criminal liability. But with respect to helping people and things like that, generally, it's not a crime unless you have a special relationship. So when you're legally required to act by virtue of law, that omission can be a crime, as I said, paying taxes. If you have a special relationship to the person who needs help, a parent has to take care of their child, give them medicine and food. A doctor has a responsibility to care for a patient, can't withhold life-saving treatment. Those are situations where there are special relationships, and a failure to do something that harms somebody could be a criminal act by virtue of the special relationship. You can also be responsible for not doing something, usually helping or rescuing somebody, if you're the one responsible for a situation where somebody needs help. So if you're driving down the road and you see somebody in a car accident who's bleeding, and you don't call 911 and they die, you're not liable for their death because you have no special relationship to them and you didn't cause the accident. On the other hand, if you caused the accident, then you would be required to help the person who's bleeding if you could, at very minimum to try to get help for them. And if you didn't, that would be an omission, and if they died, you might be liable for some lesser homicide offense like negligent homicide, or if they were injured, more possibly an assault charge. Let's talk about possession as conduct. Possession can be conduct. If the particular things you're possessing are contraband, are prohibited to possess by law, like an illegal drug, a prohibited weapon, burglar's tools, or stolen property. So possession can sometimes be conduct and get you in trouble. Note, however, that status is not conduct. Status means the condition or state of a person. For example, many years ago in the South, a state made it illegal to be addicted to drugs. In other words, to have the status of a drug addict. The courts ruled that that could not be illegal. Being addicted, having the status of addict, is not conduct that can be criminal. You can't penalize somebody for being addicted. You can penalize somebody for possessing illegal drugs. You can penalize somebody for selling illegal drugs. You can penalize somebody for injecting them into somebody else. Those are all possession actions that can be illegal. But status is not possession. Now, there is a slight exception to that, as there always is in the law, and that has to do with juveniles. If you're under 16, 17, 18 years old, it depends on the state, you have the status of being a juvenile. And while it's not a crime to do certain things like run away from home when you're a juvenile, the police do have the authority to take somebody who has the status of a juvenile who has run away from home, to take them into custody and to return them to their parents. So in most situations, status is not conduct. However, sometimes it could be, like if you're an underage person, but it's not criminal conduct. So that kind of runs through the idea of what is conduct. And as a general rule, when you're dealing with the criminal law, somebody consciously commits an act that's prohibited by law, and that's conduct that can be illegal. But there's more to criminal behavior generally than just the conduct. Other elements must be present for liability, and we're going to talk about them next. Okay, in this slide we're going to talk about two other elements of a crime. Remember, in the last slide we spoke about the need for some sort of conduct, for actus reus. Now we have to have a second element, and that is mens rea, a mental element. So you commit the act, the actus reus, but usually you have to have a certain guilty frame of mind. And this guilty frame of mind we call the mental element, or the mens rea, the guilty mind. And there are four possible guilty minds that you can commit a crime using. The first is intentionally, also called purposely. And you act intentionally when your purpose is to do the illegal act. You want to do it, you do it. You can also act knowingly. Knowingly involves being aware of what you're doing. Generally, we use intentionally when it's an action crime, like killing somebody, injuring somebody, stealing. And we use knowingly when it's a possession type crime, possessing illegal drugs or stolen property. The next two are recklessly and negligently. And they are less guilty states of mind. In both recklessly and negligently, the person commits a very dangerous act that creates a grave risk or death or serious injury to somebody. And it's an act that has no justification. There's no good reason to do it. And you act recklessly when you recognize that this is a very dangerous thing and you do the act anyway. You act negligently when you do this dangerous act without justification, but you don't realize that it's bad and there's a risk of injury. So, for example, if you drag raced down the street, a residential street, and you're driving your car at 80 miles an hour, there's no justification for that. You're not racing to the hospital with somebody dying. And it creates a grave risk of death or injury to people. Anybody backing out of a driveway, you would never be able to stop. So that would be a situation where it could be recklessly if you recognize the danger and did the act anyway. Whereas if you weren't too bright and you did this, but you didn't realize there was a danger to other people, then you would be acting negligently. The difference? Well, if you were doing that drag racing, you killed somebody, and and it could be proven in court that you recognized the risk and did it anyway, then you're guilty of recklessly killing somebody, and that would be manslaughter. If, on the other hand, you could prove that you were stupid and you didn't realize it, then you would have negligently killed somebody, and it would be criminally negligent homicide. Manslaughter might get you 10 years in prison. Criminally negligent homicide might get you a few years in prison. Keep in mind that with both recklessly and negligently, you had no intention to kill that person who you hit when you were drag racing. All you wanted to do was drag race. You didn't intend to kill anybody. That was an accident. But under the circumstances, it might be reckless or negligent. Note, when no mental element is required, just the act is required, we call that a strict liability offense. And such laws usually involve crimes where proof is hard to get, but the penalties are low. For example, speeding. Most people don't intentionally speed. Some do. But a lot of people are just driving down the highway, and especially if it's a road that's been posted too low, you think you're driving at an okay speed, but you're actually over the limit. So most people accidentally speed. And it would be impossible to enforce speeding laws if we required police to prove that you intentionally sped. So we make speeding a crime of strict liability. If the cop can prove that you're over the limit, you're guilty. And they can usually do that pretty easily with radar and what have you. Building codes and health codes are also strict liability offenses. If I owned a restaurant and my refrigerators malfunctioned unbeknownst to me, and the temperature in the refrigerator got too high, it went over 40 degrees, that's a violation of the health code, because bacteria and germs will grow in the food, and people, if they eat that food, will get sick. Now, I didn't intentionally let my refrigerator go above 40 to save money. It was an accident. I didn't even know it happened. But because a lot of people would get sick, and because it's only a fine, we make that a strict liability offense. And if the inspector comes in and sees the temperature is too high, the restaurant gets slapped with a violation and has to pay a fine, a strict liability offense. Because we want the restaurant to understand that even if it happens accidentally, they're going to be held liable. So they check those temperatures a lot, because we don't want people getting sick in restaurants. So those are strict liability offenses. Now, a third element that's required is concurrence. Concurrence between the mental state and the conduct. So if the conduct is killing somebody and the mental state is intentionally, the prosecution has to prove that they intentionally killed the person, which is usually pretty obvious. You know, if I pick up a gun, put it to somebody's head and pull the trigger saying, "I want you dead," it's pretty obvious that I intentionally killed somebody.